Now that Trump is canceling humanitarian parole and TPS programs, a lot of people are asking me, what options do I have? How can I legally remain inside the United States? And one of the options that a lot of people have been exploring are possible family petitions. And what that means is they are trying to get someone who's a family member in the US to file a petition for them so that they could fix their status. And the way they want to fix their status most of the time is through adjustment of status. So what we're going to be discussing today is whether it's actually possible for someone who's in the US on humanitarian parole or TPS to apply for adjustment of status through a family-based petition. Let's start with an example of a client I actually met with last week. This is basically a repeat of the conversation that I had with her. So I met with a woman who was over the age of 21. She entered the US on humanitarian parole from Haiti. There are a lot of Haitians in the US right now who entered on humanitarian parole. Haiti is basically like a war-torn country. There's essentially no government. It's incredibly dangerous to live there. And a lot of Haitians are inside the United States where they are peacefully and safely residing because the Biden administration allowed them to enter the US through something called humanitarian parole after the Biden administration acknowledged that there's a major humanitarian crisis going on in Haiti right now. It was a very kind act for the US government to open its arms to the Haitian people, but now the Trump administration is reversing course and taking a hardline approach and basically trying to blame all of America's problems on immigrants. Instead of the billionaires, it's the immigrants. So let's blame everything on the immigrants. And now all of these immigrants are in the US struggling to figure out what to do next. So I met with a client. She's over the age of 21 and in the US from Haiti. She entered with humanitarian parole and she's currently in a valid parole status which expires later this year. Her mother is a US citizen and her mother filed a family petition for her. And I had to have a very uncomfortable conversation with her where I explained this isn't going to work out the way you think it's going to work out. There are several problems with this type of family petition. First of all, it is a preference category, and we're going to explain what that means in a minute. And for preference categories, you must be lawfully present in the US basically the entire time that your petition is pending and until a visa becomes available. Second off, that category of petition, if you're over the age of 21 and unmarried, is going to probably take around 8 years before a visa becomes available and you can apply for your green card through that process. So let's take a step back and figure out what's the difference between an immediate relative petition and a preference category petition. Because this is going to be the difference between adjusting status in the US or possibly having no options available at all. So there are 3 types of family petitions that will allow you to adjust status in the US if you're not currently in a lawful immigration status or not in a valid non-immigrant visa status. The first one is marriage to a US citizen. In that category, you can be out of status. It doesn't matter if your visa expired 10 years ago, you could still apply for adjustment of status in the US through a US citizen spouse. The second one is if you are a US citizen and you're filing a petition for a child who's under the age of 21 and who entered the US lawfully. And the third category is if you are the parent of a US citizen and that US citizen is over the age of 21 and you, the parent, entered the US lawfully. In these 3 categories of petition, you can be out of status. The government will not consider whether or not you have unlawful presence or unauthorized employment inside the United States, and you could apply for adjustment of status in the US without leaving if there are no other complications in your case. Now, on the flip side are preference category petitions, and preference categories require you to be lawfully present in a valid status the entire time that the visa is pending, and a visa is not immediately available for preference categories, which means there's a backlog, and some of these backlogs take years. And during those years, you cannot fall out of status in the US. So preference categories can include siblings of US citizens. And by the way, that category currently takes like 18 years for a visa to become available. So if you wanted to petition through a sibling of a US citizen, you are the sibling of a US citizen and you're in the US, you would need to legally maintain lawful status for 18 years to become eligible for adjustment of status in the US. Another category is if you are over the age of 21 and a parent petitions for you. And that's like an 8-year processing time, and it turns into like a 13 or 14-year processing time if you get married. And then the final group of preference category is spouses and children of permanent residents. The backlog for that category currently is actually less than 1 year. So that might be an option for some people, but you need to be lawfully present in the US the entire time, and you cannot apply for all of these preference categories. You generally cannot file the I-130 petition at the same time as the I-485 petition. The only exception there would be if a visa is current. That means a visa is currently available, there's currently no backlog. That would be the one exception. There was actually a period of time, that like a 1 to 2 year period of time around 2021, if I recall correctly, where spouses and children of permanent residents were current. So people were able to file the I-130 and I-485 simultaneously if they were legally present in the US. For example, if someone entered as a tourist and then they married their green card holding spouse, their permanent resident spouse, if the visa category for spouses of permanent residents is current, they might be eligible to apply for adjustment of status while in the US. Whenever you're doing a preference category petition, I strongly recommend speaking with an attorney. Even if you want to file it yourself, that's fine. Speak with an attorney so that you can manage your expectations about how long it's going to take and whether or not you can even apply for adjustment of status. Over 100 times, probably in the last like 2 years, over 100 times, I've consulted with people who told me like, I'm just waiting for this petition to become current. And I had to break the news to them. You're unlawfully present in the US. Once that becomes current, you're not gonna just be able to apply for adjustment of status. You're gonna have to leave the US and go to a consulate interview in your home country because you can't apply for adjustment of status in a preference category if you are currently out of status. And if you need to leave, there's a good chance you're going to need an unlawful presence waiver. And to qualify for that, you need to have either a spouse or a parent who's a permanent resident or a citizen, and you need to show that that spouse or parent will suffer extreme or unusual hardships if you're unable to return to the US. So it's a whole thing. It's very complicated trying to adjust status through a preference category. It might not be an option if you don't have a qualifying family member to later help you apply for the waiver. So my whole point here is it's very complicated, and you should do your due diligence and your research before you even file a petition, because to be completely honest, you might just be wasting your money. Now let's bring it back to that example I gave of the Haitian woman who entered the US with humanitarian parole. So she entered legally, and she'll be in a valid parole status for another few months. What's the problem with her mother, who's a US citizen, filing a petition for her? Well, the problem is that petition is going to take probably around 8 years for a visa to become available. And the humanitarian parole is going to expire this year, at which point she'll fall out of status. So what's actually going to happen in this situation? First of all, from this year until like 8 years from now, she'll be out of status. Once the humanitarian parole expires, she won't be in any sort of status whatsoever. Even though humanitarian parole isn't like a solid status to begin with, you could still be deported even if you're paroled in the US. But let's call it a status for this video. She'll be out of status later this year. And then she's going to have to wait like another 7 years for the visa to become available through the petition that her mother filed for her. But in 7 years, when it becomes available, she'll be completely out of status. So she won't be eligible for adjustment of status in the US. So what can she do then? Well, she can leave the US and go to a consulate for an interview so that she can re-enter the US as a permanent resident. But wait, she has unlawful presence. So the moment she leaves the US with more than 1 year of unlawful presence, she will trigger a 10-year bar, preventing her from being allowed to come back. So before she leaves the US, she would need to apply for the unlawful presence waiver. that's going to take like 3 to 4 years to process. I would even get started on that process before the 8-year visa backlog expires. Like 3 or 4 years before it expires, I would get started on the unlawful presence waiver. If the waiver also gets approved, then at the end of the 8 years, we could schedule an interview for her to attend an interview at a consulate abroad and re-enter as a permanent resident. So this really ruined her day when I explained she won't be eligible for adjustment of status. And had she known this, she wouldn't have even filed the family petition. She wouldn't have asked her mother to file the petition for her, because as it became clear during the interview, during our consultation, she's not willing to leave the US. She's too afraid to attend a consular interview abroad because she's heard so many stories of people attending their interviews being denied visas or subject to extraordinary delays and not being allowed back into the US. So that ended up being a deal breaker for her. She's not going to even continue with that petition process, and now we need to find another option for her. Now, there are also a lot of people who are in the US with TPS. TPS is actually a valid non-immigrant status, unlike humanitarian parole. So TPS is a little bit more complicated. In fact, if you can validly maintain TPS the entire time you're in the US, such that you never were out of status, you might actually be able to wait it out and adjust status through a preference category. But most people are unable to maintain TPS status the entire time they're in the US up until time for adjustment of status. And in fact, with the news now that Trump is going to be canceling TPS for a bunch of countries, including Ukraine, which I hope doesn't happen, but that's what the news is saying right now, Ukrainians are struggling to find lawful options for them to remain in the United States. And preference category petitions, like a petition for an adult Ukrainian that's being filed by their parent, that's probably not going to work out because that's going to take too long. It's going to take too many years. And the person who's going to be applying for adjustment of status might not be in a valid TPS or other non-immigrant status that entire time. So Ukrainians and other people who are on TPS and who might lose TPS should really begin focusing on immediate relative category petitions, because preference category petitions might not be a viable option for adjustment of status in the future. Alright guys, that brings us to the end of today's video. If it was a little complicated, I recommend you check out my other videos where I specifically dedicate the entire video to explaining the difference between immediate relative category petitions and preference category petitions and all the subtle nuances and differences between the two categories. If you guys are interested in learning more about family-based immigration, naturalization, and changes to immigration policies under the Trump administration, be sure to subscribe to my channel. I put out several videos each week on these topics where I try to break down the complexities of immigration law. If you personally need any immigration assistance, or you want to consult with an attorney to see if you have a good strategy for the future, please schedule a consultation directly with me. You can find my information in the video description below. If you have a good case, I would love to offer representation and assist you throughout the entire immigration process. And I want to thank you guys again for watching my videos. I'll see you guys next time for another one.